Henshaw here again for the Constitutional Crisis channel. We're approaching, but not yet, at our 75th video. It's amazing how fast these have been going. Today's subject matter is a continuation of correspondence I received from the Office of the United States Attorney General pursuant to my request for criminal prosecution for violation of federal law. This letter I'm going to read to you is basically a carbon copy of the first one, but we're going to talk more about the ramifications of it and what it is these people are either not doing in these federal offices or they are choosing not to do. I don't know which. That said, I just got this letter from the Office of the Attorney General. At least this one doesn't say to whom it may concern. That's already an improvement. But, says, dear Mr. Henshaw, this response to your letter dated May 18th, 2015. This is November, so it took him 6 months. But as to the Attorney General regarding your complaint that some state Supreme Court was reviewing your writ without judicial authorization, that's not exactly what it was I was saying, but about which more later. We apologize for our delay in responding to your letter with the changeover in the office from Eric No Holder in due course. I'm sure there were some things that went on there. Your claim that the individual justices were concealing the fact that the state of California was never admitted into the Union, therefore violating Article 6 of the state constitution. Well, now, I never said that. I said concealing the fact that the state of California is no longer a state admitted into this Union. They missed it, and it has nothing to do with Article 6 of the state constitution, but everything to do with Article 4, Section 3 of the Constitution of the United States. And these people went to law school? Damn. In reviewing your correspondence further, you stated that you were a quote-unquote lawful de jure free white state citizen, which is true if we have states. If not, and not related to this letter, what I may be calling myself in the future is an inhabitant of a territory, and you'll see why later, and not a citizen of the federal government. And you complain that the United States Attorney's Office in San Francisco refuses to acknowledge your sovereignty. Again, not exactly what I said. I said I'm a member of the sovereign body politic here. I don't owe my citizenship to your 14th War Amendment, which doesn't exist. In addition, your litigation has presented examples of government illegal coercion, such as compelling state citizens, small s, small c, by the way, to purchase vehicle insurance, that's quote-unquote vehicle, as well as exposing the state's associations, bar associations, unfair monopoly over the practice of law. Those two things are true. Criminal section of the Civil Rights Division enforces federal criminal civil rights statutes pertaining to incidents of official misconduct and violent, bias-motivated crimes, whatever the hell those are. We have carefully reviewed the information you submitted, and we have concluded there is no prosecutable violation of federal criminal civil rights statutes. Accordingly, we are unable to assist you. Sincerely. Well, you sure as hell right you're unable to assist me. If you're going to read the law that way, there's no possible way for you to do it. But the problem these people have, and before I read you my reply letter to this, is that they don't research the law nearly enough. All they go back to and all they see, and you go into the law library and look even under the annotated federal codes, and all you see there with these statutes is the ones in question here, the violation of interference with postal mail, and even fraudulent records only go back to the statutes of 1909. That's way past the war between the states, and I've done a little bit further research, and those have directed me back to the revised statutes of 1875, which I've discussed in an earlier video, which aren't worth the power to blow them to hell. You got to understand what happened there in 1875, and it had nothing to do with the law. What I'm doing now is going back, and I'll find where these statutes were originally enacted, probably very early, maybe even in the 18th century. And those are the statutes we want to cite, not the revised statutes, because these are the ones that are going to get us home, because these were laws acted in pursuance of the Constitution, not in contravention of it. Now, they have to be enforced if we have the nation and republic that was ordained and established by the Founding Fathers. Simple as that. Now, the reply letter to this, and I directed it to the Attorney General, and I said thank you for your response to my letters of May 18th and November 3rd, and an additional letter of denial from the Criminal Division, also ostensibly on behalf of Ms. Fitzgerald of the Civil Rights Division. Now, I read my earlier letter in a video you'll see on here, and not only was there no reference to the Civil Rights Division, I said, if you're going to do that, dismiss it out of hand. It can't go to the Civil Rights Division. It doesn't apply here. They ignored it. Taking the three letters together, however, it is difficult to reconcile the latter with the former, as I was not making any claims for relief pursuant to any civil quote-unquote rights statutes at all. Indeed, my letter contains specific disclaimers of any such intent, since even assuming arguendo these laws were properly enacted, an issue which I have gone all in to challenge, they would have no application to a member of the sovereign body politic of the nation and republic, aka our posterity. Regarding the summary dismissal of my petition for redress of grievance pursuant to my request, as they say, you get what you asked for, although I got much more in the bargain with these dismissals. There is one way in which the letters from Ms. Fitzgerald do make sense, and with which my request to effectively dismiss the claims is in agreement. That the only entities recognized by any department or division of the de facto national government are those who owe their quote-unquote citizenship to Section 1 of the non-existent 14th War Amendment, another all-in challenge which has never even been attempted to be refuted. With the single possible exception, the gravamen of my letter was directed toward acts of fraud, nay treason, on the part of the individuals named, pursuant to their seemingly active participation in the conspiracy to close the judicial courts of California and or aid and abet the perpetual suspension of the non-statutory writ of habeas corpus, and this in times when there is no known declared state of rebellion or invasion. Parenthetically here, that would be required pursuant to Article 1, Section 9, Clause 2 of the Constitution of the United States, and there isn't one I've been able to find. If you do, please let me know. I'd love to hear about it. The slip on my part here may have been in my affidavit when I cited possible violations of 18 U.S.C. 1701 and 1702. With research ongoing on this issue, and still be ongoing, it should be noted, it could be that this reference was construed to be to a statute which depends in whole or significant part on the revised statutes of 1875, and this turns out to be true, which could in turn be conveniently construed to conform to the then recently enacted war acts by the renegade runaway Republican Congress, 39th Congress, such as the first Civil Rights Act, quote-unquote, the Reconstruction Act of 1867, and the subsequent ratification, quote-unquote, of the 14th and 15th War Amendments. Further, but not final results seem to indicate that both of these statutes are based on statutes enacted in 1909, as is also true for 18 U.S.C. 1001, and likely applies to all of Title 18. Accordingly, there seems to be no point in presenting any claims for the keeping of false and fraudulent records, most particularly such records as would have the dual effect of not only preventing at least lawful de jure jus sanguinis state citizens and or quote-unquote inhabitants of a territory, as the case may be, from being able to access any judicial court and or set a record which might be cognizable on appeal, thus destroying any opportunity for the review of a false and fraudulent record which was not quote-unquote properly set, and thus beyond the notoriously narrow scope of an appeal, with there being no right to an appeal at all, and all of this being consistent with its civil law origin. I note here, by the way, going back to Ashwander, just a quick aside from the letter, that they said in their Ashwander doctrine that the court will not pass upon an issue of constitutional law, though properly presented by the record, if there is also present some other ground upon which the case may be disposed of. And that's exactly what government does best, disposes of things. Certainly, this would be consistent with the handling of the seemingly all petitions for privileged writs of habeas corpus, which my research and analysis indicated are now based exclusively on the revised statutes and war acts as here and above set forth, yet without any factual foundation and legal basis in support of, for all apparent intents and purposes, a pattern and practice of summary dismissals of all such petitions, save some select ones by those who affirmatively raise the seemingly sacrosanct issue, quote-unquote, of effective assistance of counsel. As I would expect you to know, that's the Attorney General, the Reconstruction Act was contemporaneously held unconstitutional by the Supreme Court on a vote of 5-3 in the case of Ex Parte McCardle, 7 Wall 506. But the court also did not have the integrity to announce its opinion after a quote-unquote emergency act of Congress purportedly removed its appellate jurisdiction in the case. With this background, then, it appears that the entirety of Titles 1 through 50 of the U.S. Code owes its egregious existence to war acts. If so, this would undoubtedly account for what the de facto dragoons perceive as a perpetual state of quote-unquote emergency, which somehow entitles the usurpers to permanently close judicial courts, most particularly in the several states, and perpetually quote-unquote suspend even the non-statutory writ of habeas corpus. A little aside before I return to the letter, this is exactly what I'm complaining about with 12 U.S.C. 95A, which the Congress delegated authority to the President to declare a state of emergency so these damn Federal Reserve notes could circulate. It's exactly what I'm talking about. Back to the letter. Having closed the judicial courts in the several states, and believing that the 14th and 15th War Amendments gave the de facto National Socialist government the power to define state citizenship, small s, small c, would for all apparent intents and purposes explain how, without any perceptible authority from any provision of the Constitution of the United States, 1787 to 1791, the usurpers relegated the several states, even those which had been admitted into this union, to a condition of federal insular territorial possessions. Also clearly coming to light is the fact that the DNSG only recognizes United States quote-unquote citizens who owe such quote-unquote citizenship to Section 1 of the non-existent 14th War Amendment and its serpentine statutory counterpart, 8 U.S.C. 1324A, and thinks that all of its quote-unquote citizens are required to apply for social insecurity benefits, quote-unquote, which then makes them, quote-unquote, taxpayers, courtesy of one or another carefully concealed fiction of law, which in turn vests the DNSG with complete control over every aspect of their lives and property. One is left to wonder, however, how the members of the sovereign body politic of the nation and republic can invoke the agency of any department of government which we ordained and established to quote-unquote secure the blessings of liberty to ourselves and our posterity. And just as tellingly, upon what provision of the Constitution of the United States the usurpers in the immediate environments of 120 Broadway, New York, relied upon to persuade their servile, sycophantic satraps in Congress to unadmit all of the states and relegate them to federal territorial possessions. Despite all this, I am very thankful for your letters, as they lend a peculiarly professional provenance to my unopposed arguments as to the unconstitutionality of the war acts hereinabove mentioned. And as you should know, the civil quote-unquote rights division of this office of the Attorney General owes the entirety of its existence to the first civil quote-unquote rights act as an outgrowth of the temporary quote-unquote Freedmen's Bureau. I think even Sonia or Elena will get the obvious connection here, as will 12 of my peers. In sum, while I am very angry at yet further denials of creator-endowed inalienable rights secured by the Constitution of the United States, I am no longer surprised and will construe the current failure to communicate to be the result of the fact there is no known substantive and meaningful curricula in the mandatory public quote-unquote education system for the study of the Constitution, history, and laws of the United States, and that this regrettable situation appears to exist in many, if not all, the institutions of quote-unquote higher learning as well. So how can attorneys know any better? And this in turn likely accounts in significant part for my record against State Bar Association attorneys, modestly calculated at 13-0, and overcoming modestly calculated cumulative odds to date of 1 trillion to 1, and this almost without any opposition at all. Accordingly, I just simply have been unable to get into jail since this would require the de facto dragoons to prove me wrong in front of a jury, which cannot be done. That's my first thought upon receiving the initial unopened letter of Miss Fitzgerald, was this could be news of my indictment. I realized we would be in a similarly hopeless position, and I was thus prepared to surrender myself to the highest common law authority available and go to trial, 580 jury instructions in hand, the next quote-unquote court day. And I remain prepared for such a trial as my unacknowledged RSVPs to your predecessor, Eric No Holder, in due course, make clear, as I know our adversarial system, this is the only way to resolve the issues I present, and that my letter of May 18th and your replies will be relevant, admissible evidence establishing that there are no states in existence. So please feel free to move forward if you think you can beat me. Your prompt attention to this matter will be expected to address all correspondence to me at my address exactly as it appears herein. That's what they're getting from me. If they want to come after me, I said, please, here I am. Come and get me. And we both know you can't do it. Now, this continues my video on the letters I've received from the Office of the Attorney General. And I got a couple of pages of footnotes here I didn't read, which aren't that important. I did that for her benefit. But at the end, I have a little epilogue here about this whole business. And I say here that the Civil Rights Act of 1866, the first such law, quote-unquote, specified its subjects were to have the same rights as enjoyed by white citizens. Since the DNSG no longer recognizes the existence, let alone status, of white citizens, what is the standard by which civil rights can be judged? Now, these documents you can get, I've got them all scanned in, they're ready to go, and you request them from me at my website at ccaspari@live.com, at ccaspari@live.com. I'll be happy to send you copies of all these documents we've been discussing, and maybe those of you who might have the ability might want to forward them to Jesse Jackson and Al Sharpton and see what they have to say about it. Thank you.